I didn't raise my voice when Margaret Henley, the HOA president, slammed her manicured hand on the conference table and declared that my flagrant violations would bankrupt me if I didn't comply immediately. I just opened my briefcase, pulled out the original 1987 county zoning variance, and slid it across the polished wood surface. Her lawyer went pale first. Then her face followed. The room went so quiet I could hear the air conditioning cycling in the next office over. That variance proved every single fine they'd levied against me for the past 18 months was not just wrong, it was illegal extortion. And I had 18 months of documentation to prove it. But let me back up, because this whole mess started in the most innocent way possible. 3 years ago, I inherited my uncle's house in what used to be a quiet suburb outside Phoenix. Uncle Ray had lived there for 34 years. Back when the neighborhood was just a collection of ranch-style homes on half-acre lots with actual space between them. The house sat on a corner lot with mature mesquite trees and a detached workshop that Ray had used to restore classic cars. I wasn't planning to stay initially. I lived in Denver and had a good job in software development, but when I walked through that house for the first time after the funeral, something about it felt like home in a way my sterile downtown condo never had. The workshop still smelled like motor oil and sawdust. Ray's tools were organized with military precision along pegboard walls. There were half-finished projects everywhere. A 1967 Camaro engine block on a stand, carefully labeled boxes of chrome bumpers and trim pieces, and a workbench scarred by decades of honest labor. I found myself spending entire weekends there, just tinkering with Ray's projects and learning skills I'd never needed in my digital career. For the first time in years, I was working with my hands instead of just my mind. It was therapeutic in a way I hadn't expected. The neighborhood seemed peaceful enough. Most of my neighbors were older, established residents who'd known Ray and welcomed me with casseroles and stories about his legendary 4th of July barbecues. The HOA existed, but it seemed to function more like a loose association that handled street maintenance and organized the occasional block party. I paid my modest dues, kept the grass reasonably green, and figured that would be the extent of my involvement. I had no interest in neighborhood politics or petty disputes about fence heights and mailbox colors. That changed on a Tuesday morning in March when I found the first violation notice taped to my workshop door. The bright orange paper informed me that I was in violation of HOA Regulation C regarding unauthorized commercial vehicle storage and faced a $150 fine if I didn't remedy the situation within 10 days. I stared at the notice for a solid minute, trying to figure out what they were talking about. Then I realized they meant Ray's 1979 Ford pickup truck, which had been parked in the same spot beside the workshop for the better part of 3 decades. The truck wasn't even operational, it needed a new transmission and had been sitting on blocks since before Ray died. But according to the violation notice, any vehicle displaying commercial signage was prohibited from being stored on residential property for more than 72 hours. The faded Ray's Restorations lettering on the door, barely visible after years of Arizona sun, apparently qualified as commercial signage. Never mind that Ray had retired 15 years earlier, and the truck was essentially a memorial at this point. I figured it was a simple misunderstanding. I called the HOA management company and explained the situation to a bored-sounding woman named Janet, who assured me she'd look into it and get back to me. She never did. A week later, I received a follow-up notice informing me that I now owed $150 plus a $75 late fee. And if I didn't comply within 5 days, the fines would continue to accrue at $25 per day. The truck still sat on the same blocks where Ray had left it, but apparently it had transformed from a harmless piece of family history into a dire threat to neighborhood property values. I decided to attend the next HOA board meeting to sort this out in person. The meeting was held in the community center, a bland beige building that looked like it had been designed by committee to offend absolutely no one. About 15 residents were scattered across folding chairs facing a long table where the 5 board members sat like judges. Margaret Henley presided from the center seat, flanked by her Lieutenant Karen Walsh and 3 other residents I didn't recognize. Margaret had the kind of aggressively styled blonde hair that required weekly maintenance and the bearing of someone who'd Found her life's purpose in enforcing homeowner compliance. When I raised my hand during the open comment period and explained my situation, Margaret barely looked up from her agenda. "Mr. Peterson," she said, "ignorance of the regulations is not an excuse for violation. Your uncle may have gotten away with certain things in the past, but we're committed to maintaining standards." She went on to explain that the neighborhood had evolved and that grandfathering old violations would set a dangerous precedent. The truck had to go, or the fines would continue. Case closed. I tried a different approach. I spent an entire weekend reading through the HOA's governing documents, all 47 pages of bylaws, covenants, and regulations that had apparently been updated multiple times over the years. The commercial vehicle prohibition was indeed there, buried in an amendment that had been added in 2019, but I also found something interesting. The original 1987 covenants included a provision that any property improvements or uses that existed prior to HOA incorporation were grandfathered in perpetuity, provided they weren't health or safety hazards. Ray had bought the house in 1989, but his restoration business had been operating out of that workshop since 1991. Well before the HOA had been legally incorporated in 1995, I had documentation, city business licenses, insurance records, tax filings that prove the commercial use predated the HOA's authority. I drafted a respectful email to the board explaining this and included copies of the relevant documents. I even offered to have the truck towed to settle the matter amicably, though I maintained that the fines were invalid under their own governing documents. Margaret's response came 2 days later. It was a single paragraph informing me that my interpretation of the covenants was incorrect, that grandfathering provisions only applied to structural improvements like sheds or fences, and that I now owed $450 in accumulated fines plus administrative costs. If I wished to dispute the matter, I could request a hearing with the Architectural Review Committee, provided I submitted a written request along with a non-refundable $200 hearing fee. That's when I realized this wasn't about the truck at all. This was about establishing dominance. Margaret had decided that Ray's nephew needed to learn his place in the new order of things, and she was going to use whatever tools the HOA gave her to make that lesson as expensive and humiliating as possible. The truck was just the opening move. I paid the hearing fee and prepared my case like I was going to trial. I gathered every document I could find related to Ray's business, the property history, and the HOA's evolution over the years. I researched Arizona state law regarding homeowner associations and discovered that HOAs are required to follow their own governing documents and can't arbitrarily change the rules to target individual homeowners. I also learned that under Arizona Revised Statute 331803, HOAs can face significant penalties for imposing fines that violate their own covenants or state law. The hearing was scheduled for a Thursday evening in Margaret's living room. Apparently, the community center was unavailable. The Architectural Review Committee consisted of Margaret, Karen, and a nervous-looking man named Bob who spent most of the hearing staring at his hands. I presented my case methodically, walking through the timeline of Ray's business, the grandfathering provisions, and the legal precedent for honoring pre-existing uses. I had documentation for everything. I even brought photos of the truck from Ray's insurance files showing it had been in the same location since 1991. Margaret listened with the expression of someone enduring a particularly tedious presentation. When I finished, she glanced at Karen, who shrugged, and then announced that the committee had reviewed my materials and found them interesting but irrelevant. The grandfathering provision, she explained, was intended for structural improvements that added value to the property. A broken-down truck with faded commercial lettering was neither an improvement nor valuable. The fines would stand, and if I didn't remove the truck within 30 days, additional penalties would apply. I spent that night lying awake, staring at the ceiling and feeling the familiar knot of frustration that comes with being cornered by people who have just enough power to make your life miserable, but not enough wisdom to use it responsibly. I could have paid the fines, junked the truck, and moved on with my life. Part of me wanted to, but something about Margaret's smug certainty that she could rewrite history to suit her purposes made me angry in a way I hadn't felt since I was a kid. Dealing with playground bullies, the next morning, I called the county zoning office and requested copies of all permits and variances associated with my property going back to 1987. It took 2 weeks and cost me $47 in copying fees. But when those documents arrived, I found something that made me sit down hard in Ray's old desk chair. In 1987, 2 years before Ray even bought the house, the previous owner had applied for and received a special use variance allowing light automotive repair and restoration services to be conducted on the property as a home-based business. The variance was tied to the land itself, not to any individual owner. It had no expiration date. That variance predated the HOA by 8 years. It was issued by Maricopa County under state authority that superseded any private homeowner covenants. Not only was Ray's truck Legolini automotive business operating on that property was explicitly protected by county law. Margaret's interpretation of the grandfathering clause wasn't just wrong. It was irrelevant. The county had already granted me the right to operate a commercial automotive business, and no HOA could override that authority. I made copies of the variance and drove to the county's planning office to speak with someone in person. The clerk, a middle-aged woman named Rosa Hood, apparently dealt with HOA disputes before, reviewed my documents, and nodded knowingly. "Oh yeah," she said, "we see this all the time. HOAs think they can override county permits, but they can't. If you've got a valid special use variance, that's state law. They can't touch you." She made a note in the computer system confirming the variance was still active and gave me an official letter stating that any automotive repair or restoration work conducted on my property was in full compliance with county zoning requirements. Armed with this new information, I sent another email to Margaret, this time copying the entire board and the HOA's management company. I explained that my property held a valid county variance that explicitly authorized automotive commercial use, that this variance predated and superseded any HOA covenants, and that I expected all fines to be reversed immediately. I attached copies of the variance, the county confirmation letter, and relevant excerpts from Arizona state law regarding the primacy of county zoning decisions. Margaret's response came faster this time, and it revealed just how far she was willing to push this fight. Not only did she refuse to acknowledge the county variance, she doubled down. The variance, she claimed, had been issued to a previous owner and didn't transfer to subsequent owners without specific HOA approval. Furthermore, she argued, allowing commercial activity in a residential neighborhood would violate the HOA's fiduciary duty to protect property values. As a result, the board was imposing an additional $500 fine for continued commercial vehicle storage and a $300 fine for conducting unauthorized business activities. She was making it up as she went along. None of that was in the HOA covenants. County variances absolutely transfer with property ownership unless specifically limited by the issuing authority. But Margaret was betting that I didn't know enough about property law to call her bluff, and that I'd eventually get tired of fighting and just pay whatever she demanded. That's when I stopped trying to reason with her and started building a case. I documented every interaction, saved every email, and photographed every violation notice she taped to my door. When she claimed I was conducting unauthorized business activities, I requested specific evidence of what business activities she was referring to. When she couldn't provide any because I wasn't actually running a business, just storing Ray's old truck, I demanded to know how she could find me for activities that weren't occurring. The fines kept coming anyway. By November, Margaret had assessed me for violations ranging from excessive noise during construction hours. I'd replaced a broken porch light on a Saturday morning to failure to maintain approved landscape standards. The mesquite trees were shedding leaves in autumn. Each violation came with its own fine, late fees, and administrative costs. The total had reached $30,000, and Margaret was threatening to file a lien against my property if I didn't pay within 30 days. That's when I hired an attorney. Not just any attorney, I found someone who specialized in HOA disputes and had a reputation for making life difficult for overreaching board members. Her name was Sarah Chen, and she'd been fighting HOA abuse cases for 15 years. When I walked into her office with 2 banker's boxes full of documentation, she actually smiled. "This is either going to be very expensive or very satisfying," she said. "Let's see which one." Sarah spent a week reviewing everything I'd gathered. And when she called me back, her voice had the tone of someone who'd just discovered a rich vein of gold in their backyard. "Mr. Peterson," she said, "you don't just have a case. You have a federal case. This HOA has violated so many statutes, I'm not sure where to start." She explained that Margaret had crossed the line from aggressive enforcement into what's legally defined as harassment and extortion. Under Arizona law, HOAs can't impose fines that aren't specifically authorized by their governing documents, and they certainly can't make up new violations to punish homeowners who challenge their authority. More importantly, Sarah had discovered something I'd missed. When Margaret started imposing fines for violations that weren't actually listed in the HOA covenants, she'd exceeded the scope of the association's authority. Under federal fair housing law, that kind of selective enforcement can constitute harassment if it's targeted at specific individuals. And when an HOA threatens to place liens for invalid fines, that's extortion under both state and federal law. Sarah filed 3 separate actions. First, a motion in state court to invalidate all the fines and remove any liens or threats of liens against my property. Second, a complaint with the Arizona Department of Real Estate alleging that the HOA management company had failed in its fiduciary duty to ensure compliance with state law. Third, and most importantly, a federal civil rights complaint alleging that Margaret and the board had engaged in a pattern of harassment designed to force me out of the neighborhood. The first hint that things were changing came when I received a certified letter from a different attorney, not the HOA's usual lawyer, but someone from a larger firm that specialized in municipal defense. The letter informed me that the HOA board had voted to suspend all pending fines against my property pending further review of the relevant documentation. It was signed by someone I'd never heard of, and Margaret's name was nowhere on it. I found out why a week later when I ran into Bob, the nervous guy from the architectural review committee at the hardware store. He looked like he hadn't slept in days. "That attorney of yours really stirred things up," he said, glancing around like he was worried someone might overhear. Margaret got served with papers at her house. Karen, too. The management company dropped us as clients. "We've got an emergency board meeting tonight to figure out what the hell we're going to do." The emergency meeting was held in the same community center where this whole mess had started. But the dynamic had completely shifted. Margaret was there, but she was sitting in the audience instead of at the board table, looking like someone who'd just watched her house burn down. A new lawyer was running the show, a calm, professional woman who introduced herself as the HOA's interim legal counsel. She explained that the board had voted to settle all outstanding disputes and implement new procedures to ensure compliance with state and federal law. That's when I stood up and walked to the front of the room. I'd brought my briefcase, the same one I'd carried to that first hearing in Margaret's living room. But this time, I wasn't there to plead my case. I was there to accept their surrender. Sarah had advised me to let her handle everything, but I wanted Margaret to see my face when justice finally caught up with her. I opened the briefcase and pulled out the settlement agreement. In addition to invalidating all $30,000 in fines, the HOA was paying my legal fees, issuing a formal apology, and implementing new governance procedures to prevent this kind of abuse in the future. Margaret was barred from holding any board position for 5 years. The management company was facing sanctions from the state that would probably put them out of business, and my county variance was formally recognized and recorded in the HOA's official documents, ensuring that no future board could challenge it. But the part that satisfied me most was a small clause Sarah had insisted on including. The HOA was required to send a letter to every homeowner in the neighborhood explaining what had happened, acknowledging that the fines had been illegal, and outlining the new procedures that would prevent similar abuses. Everyone would know that Margaret's reign of petty tyranny had ended because one homeowner had decided to fight back. Margaret didn't say a word during the entire meeting. She just sat there, staring at the table, while her lawyer explained the terms of the settlement and the new board voted unanimously to accept it. When the meeting ended, she was the first person out the door. I haven't seen her at a neighborhood event since. The aftermath was quieter than I'd expected. Karen moved away 3 months later, apparently. Her husband got a job opportunity in another state that she couldn't pass up. The new board is run by actual adults who understand the difference between maintaining community standards and harassing their neighbors. They've streamlined the violation process, eliminated most of the petty rules that existed primarily to generate fine revenue, and instituted actual due process procedures for disputes. My relationship with the neighborhood has improved dramatically. The same neighbors who'd avoided eye contact during Margaret's campaign of harassment now wave when I'm working in the yard or stop to chat about Ray's truck, which still sits in the same spot where he left it. Some of them have even apologized for not speaking up during the dispute, though I understand why they stayed quiet. Nobody wants to make themselves the next target of a vindictive HOA board. I finally got that truck running last spring. It turned out the transmission just needed some minor adjustments and fresh fluid. Ray had been more careful with maintenance than I'd realized. I've been driving it to the hardware store on weekends, partly because it's useful for hauling materials, but mostly because I like the way it feels to drive something that Ray built with his own hands. The faded Ray's Restorations lettering is still visible on the door, and I've decided to leave it there as a reminder of what this whole fight was really about. Sometimes, I wonder if I should have just paid the original $150 fine and moved on with my life. It would have been cheaper, faster, and infinitely less stressful. But every time I think that, I remember Margaret's smug certainty that she could rewrite history to suit her purposes, and I'm glad I fought. Some battles are worth having, not because you want to fight, but because someone needs to prove that bullies don't always win. Ray would have approved.